Welcome, everybody. My name is Jeff O'Brien. I'm a partner with the Minneapolis office of the Hush Blackwell Law Firm. I'm going to be talking today about brewery leases, key provisions, and practical tips. I want to thank Andrew and the craft beer professionals team for having me today. Really excited to talk about this topic because it's one of those areas where I get to talk about kind of both areas of my practice. Just a little bit background on me. I do both corporate and real estate work with a heavy concentration of food and beverage clients, breweries, distilleries. Now doing some hemp and cannabis stuff as well. And the other half of my practice, I do real estate law. So a lot of commercial lease negotiations, a lot of commercial lease drafting. Been doing this for quite a while. I'm sitting here in the suburbs of Minneapolis, Minnesota. I'm licensed to practice here in Minnesota, also in Wisconsin, Iowa, and North and South Dakota. My firm is all across the country. We've got over 1,000 attorneys in 40 different states and 21 brick and mortar offices. And we have an alcoholic beverage initiative, and a lot of attorneys in our firm also handle some of these issues. So a lot of this is going to be called from practical experience. You do this enough, and you have good stories, you have bad stories, you have lessons learned, and this is an area that it's a pretty key component for a brewery, pretty much all through the brewery's existence. Now, for those that are owning the property that they're operating the brewery on or in, it may be of secondary importance, but there are reasons why you still have to pay attention to your lease structure. So we're gonna talk about that as well. So we're gonna talk about things kind of all the way through the life of a brewery in terms of the negotiating the original lease, ongoing issues, and then maybe possibly some exit strategies or renewal issues. So I don't know how many folks are watching this live, but if you are and you have some questions, feel free to use the comments section and drop a question. I'll try to answer it as best I can. If it's going to come up someplace else in the presentation, be patient. We'll get there. So with that, we'll dive in and start talking about some of the issues. So we're going to start here at the very base level in terms of the types of commercial leases. Now, with commercial leasing compared to, say, residential leasing, there's not a lot of statutory law or some of the kind of the consumer protection stuff that comes up when you're dealing with residential landlord tenant law. Way back in the early days of my practice, I did do some residential landlord tenant law, and it is a very different area of law. One of the biggest issues, I think, that with commercial leasing, it's assumed that both parties being in business, having a certain level of sophistication, likely having a team of advisors, which could be a broker and an attorney, it may be the insurance person, whoever, that you're going to be a little bit more equal footing compared to the residential lease context where the law affords more protections to tenants. So be aware of that going in. I would say the first lesson, and maybe it's shamelessly self-promotional, but the first piece of advice that I can give is make sure you do have a real estate attorney representing you when you're negotiating a lease. And going back even further to the letter of intent, a lot of times what happens is you engage a broker. Both parties, a lot of times there's brokers out there that are paid by landlords to go find tenants for them, and they get commissions for that. So you have a broker on both sides. The tenants broker is sometimes called the tenants rep. But anyway, so you'll negotiate that letter of intent. It'll lay out kind of the basic lease terms. Sometimes I'm involved with that. More often, I get handed the letter of intent and told to either draft the lease or here's a draft of the lease from the landlord. Can you review this? And that's how the process starts. And one of the basic building blocks of a lease is the structure in terms of, is it a gross lease or a triple net lease, and there's meaning to that. A gross lease is where you have a single, like a flat amount that is paid all in per month for rent. That means it's going to cover rent, it's going to cover utilities, it covers everything. That's all the tenant pays to the landlord, and the landlord is assumed it has some idea as to what it's going to cost on their end for expenses such as taxes, such as utilities, such as their holding costs, and they just kind of bake it all into one number. You don't see the gross lease structure a lot when you're dealing with a third party landlord. I use a gross lease if I have my client that is also owning the property that that is, that's being used for the brewery, and you want to separate. We use a lease still simply to separate liability from the business and the real estate. The real estate's a valuable asset. We don't want to have any liability from the business come over and attach to the real estate. So we have two separate entities. You have a lease. I sometimes call these gross leases a pass-through lease, but you have a pass-through lease between the operating brewery entity and the real estate entity, and you're basically passing off enough in rent per month to cover the mortgage, taxes, and insurance. That's the most common use of a gross lease structure in the brewery context. More often, we get what we call the triple net lease. And the triple net lease is you have a base rent, and it's usually based on it's a certain amount per square foot, and it's a monthly amount paid. There'll be escalators built into the lease, so you could have, say, a 5 or 10-year lease. It's not uncommon to see a 3% annual increase in the rent. It's negotiated, but that's kind of typical. It all depends sometimes in terms of how the real estate market's going, but you're going to have some sort of escalation in there. So that you'll have your base rent you'll have the additional rent, and that would include amounts for taxes, for insurance, utilities. Utilities can go a couple different ways. It can be baked into the additional rent payment that goes along on a monthly basis, or you can have situations, and I've had it with a lot of, particularly with this area, with breweries, with restaurants, anybody where there's like say the water usage might be more or the electrical might be more, where if you have things separately metered at the space, the tenant can pay for those things directly and separately outside of the lease. And then you have insurance. You also get into what we call CAM charges. CAM is short for common area maintenance. It's sort of a catch-all for any sort of common expense related to the property. And if your brewery is leasing 100% of the space, all of these expenses are going to come back and be paid by you as rent over a period of time. If you're in a multi-tenant facility, what happens is you end up with a proportionate share of those charges paid through the lease, and the lease should specify what your proportionate share is, whether it's 5%, 10%, or 100%. But common area maintenance charges are things such as snow removal, lawn care, property management. There's a whole laundry list of items that can be put in there. They can be negotiated sometimes. Sometimes you see some additional administrative fees added that you might be able to negotiate out of, but it's kind of it's a big laundry list of items. Most leases, whether it be in the letter of intent or somewhere in the lease itself, initially will have some sort of estimate of what the CAM costs are for the first year. It'll be very clear that it's specified that those are estimates, and that it would be non-binding. And I have unfortunately had a situation where I had a tenant, and the landlord put out the CAM estimate, and my client relied I too much on the estimate, and the estimate ended up being way low. And so client got kind of caught flat-footed on it, and the landlord was just one that wasn't going to negotiate on it. So be aware when you see those kinds of estimates put out there, they are just estimates. So that some of those things can change, but that's kind of the difference between a gross lease and a triple net lease. Is you're going to end up paying for a few more things. It's a more of a the market usually dictates a triple net lease. That's going to be the most common. It could happen if you get the right landlord, or if you have like such the situation where you're also the property owner and you need something in place to have the paper trail to show the separateness of the two sides, that you get that gross lease. But more likely you're not. You're going to get the triple net lease. Um, so let's start with some of the early issues in terms of what kind of issues are you going to be concerned with as you negotiate your first brewery lease, or let's say a lease for a new space. Let's say you're expanding, or you're relocating into a larger space. What types of things do you want to be concerned with? Well, initially you want to look at financial incentives, and the two areas that there's a lot of negotiation about is rent abatement and tenant improvement allowances. So what is rent abatement? Rent abatement is going to be that rent-free period. Usually you can get a few months up front in the lease of a rent-free period that allows you to be in the space, maybe making improvements, um, in anticipation of opening the business without having to pay rent. Sometimes it's only monthly rent that's abated. The CAM charges, if you're in there actually using electricity, using heat, some of those things, the landlord's going to want you to pay for those. In terms of this context with the brewery, what would be the importance of this? Well, you think about the timeline of getting your brewery going, getting TTB approval, getting state approvals, any local approvals for licensing. A lot of times the government entities, the licensing agencies, want information about your business structure and your financing and your location, where you're going to be. I mean, if you're talking about the TTB with your brewer's notice, you have to give them a floor plan of how you're going to lay things out. You kind of need to know the space. You're going to have that space leased, and so you want to try to negotiate in a number of months of rent free time period, so that you're not draining down all your startup capital just paying the lease. What's typical? These things are all product of negotiation, but it's not uncommon to say somewhere in the range of 1 to 6 months of rent abatement, like that rent free period. And like I said, it could be all of it. It could just be monthly rent, and you're still having to pay CAM charges. But every little bit helps. It's kind of a key thing. It's a good barometer to know if you've got a landlord that understands the industry and wants to be a partner with a brewery. Not every landlord looks at it that way. They look at it as a tenant is a tenant is a tenant, and they want to just um, have rent paid on day one, because they've got, it's part of their investment portfolio as this property, and they need to get revenue from it. That may not be a good fit for a landlord for for a new brewery, or a relocating brewery. When it was really boom times here in Minnesota with the breweries opening, there were a handful of real estate folks in town that really held themselves out to be partners in the projects and the process, and maybe would help acquire multiple properties and had a portfolio of brewery tenants, and did quite well, actually. So you want to just be careful in terms of making sure that your landlord understands, and I'll get to some other issues in that regard a little bit later. The other piece besides rent abatement, that one of the key economic piece up front, is also what amount of tenant improvement allowance that you might be able to get from the landlord. So what is a tenant improvement allowance? Well, you're going to have improvements that you have to make to the space. Some of them will stay with the building even after you're gone. And so that's kind of the thinking behind asking the landlord to contribute to some of that. It's an economic incentive for the landlord as the property owner to land the brewery as a tenant. And so, it's again all negotiated. It's something you want to put together your construction budget up front. You want to find out from your ownership group, your investor group, what you might be able to, what the group can come up with in terms of, funds to help build out the brewery. You'll want to talk to your lender to find out how much of a loan that you can get that would include the build out. And then at that point, if there's any more room, if you want to have some breathing room in the budget, if there's a gap, you want to negotiate that into the lease have the landlord cover certain amounts of the improvement. Those can be done in terms of the negotiation. You want to be careful in terms of what the language says about the tenant improvement allowances, because there's different ways that you could have this structured. It could be done as a reimbursement, meaning that you as the tenant actually pay the contractors and subcontractors for the work and then submit invoices or receipts to the landlord or their property manager, and there's a lease calls for within a certain time period to have those amounts reimbursed by the landlord. If I'm representing a tenant, I'm not a big fan of that type of structure, because again, you're having to outlay the funds and wait for the landlord to reimburse you. Anything, we lawyers, anything that could possibly present a risk, not something that we want to have our clients take on. I would rather have a situation where the landlord, once the improvements are completed, that the landlord can come through, inspect, sign off, and cut the checks directly, for the improvement allowances, rather than where the tenant has to outlay the funds and then wait for reimbursement. So, a couple different ways that you can go there. Just again, this is one of those things that I mentioned before, the importance of having professional advice, experienced professional advice when you're negotiating the letter of intent and the lease, to make sure that that these things are considered. And when you get to the improvement allowance, getting into the nuances of the language and making sure that that it's drafted in a way that's as favorable as possible to you as the tenant. A couple of issues that come up, particularly with some of these issues are coming up time and again as I negotiate commercial leases, and some of these issues are, I would say, heightened because of the business being a brewery. And I highlight two here for discussion, which is utilities and the HVAC repair and replacement. HVAC, in case for anyone that doesn't know, is heating, ventilation, and air conditioning. So with utilities, as I alluded to earlier, there's a couple different ways that you can structure utilities in a commercial lease involving a brewery. One is, if depending on how the building is, if there's a separate meter for the space where your brewery is located, you can have set it up so that you as the tenant pays the utilities directly. Sometimes a multi-tenant landlords more likely would want to do that, because with a brewery, let's say, with certainly possibly with electric, but certainly with water, your business is probably going to use more than maybe some of the other businesses in the multi-tenant facility. And so a landlord very often will say, we're gonna separately meter water and electric for you, maybe gas too, but those utilities, so that you can just pay those your actual charges directly to the utility provider, and it's not get doesn't get rolled up into cam costs. That's the other way to do this, which would be that the landlord is paying for, is paying the utilities and is prorating those costs back to each tenant based on their proportionate share. Um, the separate metering has, at least in my experience, has been more common, again because a brewery is going to use more of those utilities than perhaps some other tenant in the facility. And so it just ends up being a little bit a little bit more straightforward, a little bit simpler to manage, to have the brewery pay the utilities directly. Um, the HVAC repair and replacement. There's other issues that come up when you're negotiating. The maintenance in general ends up being um, a negotiating point in the lease. The things such as the foundation, the roof, the windows, the doors, all of these different things can be points of negotiation as to who's responsible. Generally speaking, the landlord will want to cover the foundation and the roof and probably not much else. And of course, tenants want to have the landlord cover more of that. Um, and just charge them for a proportionate share. Some of it depends on the nature of the property. Again, is the brewery going to be the sole tenant, or is it one of many tenants? If it's one of many tenants, you're more likely to get more of the landlord to handle more of the maintenance items and bill them back, versus if you're the sole tenant, the landlord's going to try to put more of that back on you to be responsible for. With HVAC repair and replacement, this is becoming, I negotiate leases for businesses in a lot of different industries, and this aspect is becoming more and more of a point of negotiation in a commercial lease. It used to be that it was kind of accepted that a tenant would be responsible for maintenance, maybe some repairs, but landlord would cover replacement. I have seen a number of times where the landlord, at least in the first draft of the lease, proposes that the tenant is responsible not only for maintenance and repair, but also replacement. Um, and here's where it starts to get to a couple different options. Some landlords will require a tenant to have a maintenance contract with an HVAC contractor, so that there's regular maintenance of the HVAC system. That may end up being something that is a condition to the landlord taking on the replacement costs for any pieces of the system that have to be replaced. So that's one area where one kind of counter is, they may say, if you as long as you get a professional maintenance contract and have somebody looking at it regularly, I'll pick up the cost of replacement should replacement be needed. Another way I've seen it handled is on the tenant side to say, we're responsible up to an annual amount of X. It could be 500, 750, 1500, whatever you negotiate, so that the tenant may contribute something towards those issues, but at when it hits a certain dollar threshold, now it kicks in where the landlord has to cover any overage. So that's another way of handling this. Sometimes it'll say the landlord's responsible for replacement of a unit, but it's the landlord's decision as to whether or not um, whether or not the unit needs to be replaced. So it's in the landlord's discretion since they're writing out the check. So there's no one way to do this. There's no I would say I don't necessarily know if there's a preferred way. I don't like to have my clients being on the hook for replacement of HVAC. I mean, if what happens is the tenant ends up paying no matter what. If there's pieces of the HVAC system that have to be replaced, what ends up happening is the landlord will expend the funds to replace those units, but it ends up getting billed back to the tenants in the property as additional rent. And there are rules, the IRS provides rules for amortization of those types of capital improvements, like an equipment replacement for a building, over its useful life. So and this comes up actually quite a bit towards the in the context of the end of the lease. Let's say you only have 2 or 3 years to go on the lease, and there needs to be replacement of one or more of the HVAC units. What By having that language in the lease that it has to be amortized over the useful life in accordance with IRS regulations, the significance of that is you could have a useful life for an HVAC unit of say 15 years. If and you as the tenant may end up only covering the 3 of those 15 years if you only have 3 years left on the lease and you don't end up renewing the lease, versus we're going to just make we're going to replace it and you're going to pay everything right now, or we're going to just stretch it over shoehorn it into the final 3 years of the lease. Doesn't necessarily work that way. You want to, if the landlord's required to amortize it over useful life, there's IRS tables and guidance as to the various components, and it'll help it'll help the tenant possibly save money in the long run if they don't have to pay for that entire time if the lease period is shorter than the useful life of whatever is being replaced. So that's again back to having professionals like your broker, like your attorney involved. I always tell clients, you may see something one time in your business. We do this all the time. I may see these issues multiple times in a month, and we just know when I'm handed a draft of a commercial lease, particularly with respect to a brewery, I know what issues to look for. I know I'm going to go to the HVAC. I know I'm going to go to the utilities. I neglected to mention when we talked about the CAM charges, the one thing I always like to include there is audit rights. If you're paying additional rent and there's a whole laundry list of operating expenses that the landlord is charging back to the tenant, I put language in that on an annual basis for a period of time, once the landlord provides that statement of all, the background of all the expenses, that my tenant client has the right to audit the records and confirm that those, that the amounts that they're paying are in fact correct. And if there is a difference in my client's favor, that money there's an adjustment made and it comes back to us. So that's another one of those issues you want to just be aware of as you're negotiating these leases. Obviously there's always liability issues involved with a lease. You've seen stories these days. Some breweries aren't doing well, unfortunately, and occasionally it becomes necessary to close your doors. and it doesn't necessarily mean that you're closing the doors with the lease expired. It may be that you have to close your doors before the lease is up, and of course then you have to worry about, what do I do with this space? And it's a bigger issue if you or some of your partners have personally guaranteed the lease, which is a lot of times what happens in a context of a new lease. Very few landlords are going to lease a space, particularly to a new business, without having some sort of security um, for the performance of the obligations under the lease, which usually comes in the form of a personal guarantee. I mean, now I have one client that has a like there's not a brewery, but it's a multi-location business. We have a leasing entity. You'll see this sometimes with restaurants. We'll do this too, and maybe it's a big enough. Maybe a brew pub operation might do something like this, where you have a leasing entity that leases all the spaces. We have a corporate guarantee from the parent company, and then the leasing entity then leases to each subleases to a location entity, and that way we don't have any of the members doing giving out personal guarantees. That always is that's the luxury that a brand new brewery or a brewery they're relocating into a new space may not have. Landlord has no track record, no history with this tenant. They want some assurances that they're going to get paid, and that's why they ask for personal guarantees. So if you end up with a default in the lease, let's say that the brewery goes dark, and you and and you have possible liability under a personal guarantee. um if you're in it's a bigger issue if you're in a multi-tenant property. If it's a single tenant property, the landlord may be more inclined to go out and put the for lease sign out and try to re-rent the space. And a commercial lease typically gives the landlord the ability to retake possession and release the space without necessarily terminating the current lease. So there's still possible liability for the unpaid rent for the months where the space is empty. The bigger concern is when you have a multi-tenant facility and the landlord may have other vacancies in the property, and they may not necessarily be inclined to focus on re-renting your space versus another vacant space. And so and this is one of the areas in many states. Where I'm in Minnesota, it's the law, but also in other states, that unless the lease requires mitigation, there is no duty on the part of the landlord to mitigate its damages. Now, what does that mean? In layperson's terms, it simply means that the landlord has to take efforts to try to re-rent the space. If the landlord can't just sit and have the space sit dark and pursue the guarantors under their personal guarantees, if there's language that says you have to try to re-rent the space. What are the advantages of having that kind of a clause in there? Well, if the landlord is obligated to use some level of effort to re-rent the space, if they get another tenant that wants to rent it, but say that tenant wants to rent it for $1 a square foot less, um, you know, per month or per year, whatever, than what your brewery was, your liability to the landlord is only going to be the difference between what they're getting now and what they were going to get, or what could have got if you hadn't gone dark. And so that's a huge thing, particularly when you've personally guaranteed a commercial lease, which is not cheap. It could be the difference between having to file bankruptcy and having and not having to file bankruptcy. Um, in terms of personal bankruptcy, to get out from under your guarantee, because practically speaking, that's sometimes the only way that you can get out of it at that point. So you want to ask for the duty to mitigate to be included in the lease. I can tell you, in almost every lease that I've received from a landlord, it's not in there. I would say better than 50% of the time, we do, when we ask for it, we get it. There are certain landlords that just like, no, we're not going to agree to it. It usually comes up in the multi-tenant context, a multi-tenant property context. Even then, you can get some language in there that says that, they don't have to take, you know, extraordinary efforts to re-rent that space over others, but they have to do something. So again, another negotiated point, but it's an important one, particularly thinking, we always have to, we hope that these businesses open and do really well forever and ever and ever. But the reality is, markets ebb and flow. And, you know, you don't know what's going to happen. So you need to plan for contingencies for worst case scenarios. And this is one of those issues. What would happen if the brewery would go dark and I'm exposed on my personal guarantee? Well, you want to try to get yourself in a situation where the landlord is obligated to try to re-rent the space. Another issue that comes up, and this is more unique to where you have the brewery operating in a space with other tenants, is dealing with complaints from the neighboring tenants. And I'll tell you, the two areas which arise the most in this context are noise and smells. There's a particular clause in just about every commercial lease that says that the tenant will not permit or will not cause to have unreasonable odors and smells, you know, happening at the property, in the leased premises. Now, those are pretty subjective terms. I have seen the ways that we've dealt with this in some instances with respect to the smells side. And I've seen this arise more than the noise piece, but we'll talk about both of them. But when I see that clause, that this kind of boilerplate clause about not causing any unreasonable, or not permitting any unreasonable odors or noise, with odors, I put in some extra language, and I put in this, and I say that the landlord is aware of the typical odors associated with a brewery business, and agrees that such smells do not violate this provision or this section, right? So you sort of kind of kick it back to a landlord of, you can't argue that you didn't know that there were going to be odors associated with this business. Because what can happen, and I've seen it happen, unfortunately, a couple of times, is you have a neighboring tenant who may be a larger space or maybe paying more in rent to the landlord than what you are, and they complain because of the smells and claim that the landlord is in breach of their lease by permitting this. So the landlord turns around and comes down on the brewery. So by having some protective language in the lease to say landlord knows that there are smells associated with a brewery, and they agree that those smells, those typical smells, aren't a violation of that no unreasonable odors section. So that's one piece of it. With the noise, again, you could do the same thing, that they're aware of the, certain noises associated with a brewery. I've also had clients that specify a certain decibel level, that it wouldn't be considered unreasonable unless it exceeds this decibel level. So a couple different ways to deal with that, but it's something that you want to try to head off and take care of in the original lease negotiation, so that it doesn't become a problem later. Okay, so a couple of those couple issues there you want to think about from a liability standpoint is the duty to mitigate and dealing with complaints from neighboring tenants. The other kind of liability protections, obviously, you're going to have a requirement of having insurance and naming the landlord as an additional insured. And I always tell clients, when you see the limits that are put into the lease in terms of insurance, make sure you show it to your agent, your insurance agent, and confirm that those would be reasonable. But those kinds of things you just got to deal with. It's when you're starting a brewery or your brewery is expanding into a new space, you're excited, it's positive, you foresee it continuing. But we always joke about how lawyers always have to have this dark view of humanity and have to think about what could go wrong, and so try to guard against those things, you know, in the event that they do come to pass. So, and then so those are kind of the original kind of negotiating points for the brewery. So you've got your structure of your lease, your amounts of monthly rent, your rent abatement, your cam charges, audit rights, um, those things, your liability, the duty to mitigate, liability protections, the wordsmithing the odors and smells clauses or the odors and noise clauses. And then you get into some these other issues, these the kind of the later year issues, um, and some more specific issues in terms of what happens with the property going forward. It's very common to have renewal options laid out in the original lease. It may be that, and a lot of times, what might happen is let's say you're getting an SBA loan, and the SBA requires that the term of the lease be at least as long as the term of the loan. And the landlord may initially say, we're going to do a 5-year lease, but let's say the SBA loan is 10 years or 15 years, just for examples. So you can use options to renew. My understanding is that the SBA will look at renewal options as in terms of if you've got the, the 5-year plus 5-year plus 5-year, they look at that as 15 years and they would be okay with that. So what you typically have with the option to renew, there's a couple of components. Usually the landlord's going to say that the tenant can't be in default. Some landlords are stricter. They'll say that the tenant couldn't have had X number of defaults within the original lease term in order to exercise, but there's some sort of a good behavior trigger where before once the tenant it hasn't been in default or isn't in default, that's when they can renew their lease for an additional term. It usually is the renewal terms are usually the same length as the original term. So if it was a 5-year lease, you might have an additional 5-year term or 2 additional 5-year renewal terms. Other things that get specified in terms of the window for when you would have to exercise the renewal option, it could be anywhere from 30 to 60 to 90 to 180 days. I've seen some that have been a year out, but you have to be aware when it's negotiated and make sure you calendar what the deadline is to give notice of that you're exercising your option to renew and how that's done. Is it done in writing? Is it done via email? Is it done in a certified letter? You have to look at the lease to find out how notices are to be given and how that option renewal notice is to be given to make sure that you comply with the letter of the lease in terms of doing that. Because if for some reason you're in a somewhat contentious relationship with your landlord and you maybe don't technically exercise the renewal option correctly, they may use that. They may not show any mercy. They may require strict adherence with the provision because they want to the relationship. So just be aware of if you have renewal options in the lease, what the mechanics are of doing that and making sure that it's done properly. Options to purchase and rights of first refusal are a little bit different creature. This here we're talking about that you having the right to purchase the property from the landlord, and it comes up in two different situations. Um, Getting the option to purchase the property, that's less common. I have one right now. I have a restaurant client that we did get the option to purchase, and so we're going to close this week on the purchase of the real estate. And what would be the rationale for exercising an option like that? It does happen that sometimes you look at what your rent amount is going to be, and I should mention with the renewal options, you'll usually specify what the monthly rent escalators are in advance, rather than leaving it to chance when and renegotiation at the time that the renewal happens. But back to the option to purchase, I've had situations where my client, who's the tenant, looks at what their rent is going up to, realizes they can pay less if they were to finance the purchase of the property. So they exercise an option to purchase because they had it available. More often in this context, you might have what's called the right of first refusal. Now, what does that mean? Well, if any of you have partners in your business and you have buy-sell agreements, you know what a right of first refusal is. Meaning, if in this case, if the landlord goes to sell the building, they have to offer you the right to purchase on the same terms that they're offering to the third party. And this can work a couple of different ways. The most like, and I've seen one. This is one where I had the property owner where we had to negotiate the purchase agreement. All the contingencies had to expire. So financing, government approvals, all those kinds of things. And then we had to submit to the tenant, and they had the right within a period of time to exercise, which they did. And so we ended up closing by selling it to our tenant versus selling it to the third party that had originally, wanted to buy it from us. So you can have that situation where you have to fully negotiate the purchase agreement and then hand it off to the tenant. That's, from a property owner standpoint, that's not great, because that's a lot of effort to get and still to work with a buyer who may still run the risk of losing the property if they know that the tenant is waiting in the wings and could exercise rights of first refusal. The other way to do it is before the property is listed, to go to the tenant and negotiate, to have the property owner negotiate with the tenant as to a termination of that right of first refusal, to free things up to let them sell the property. Like I said, this doesn't come up a lot, but it's something that you can always ask for as part of lease negotiations at the beginning, and see if they go for it. If they do, cool. If not, it's not usually a deal breaker because it's a hard thing to get. But just be aware that, if it's something that you maybe ultimately would like to own the building, throwing that out there as a negotiating point, getting the option to purchase it at some point, or the at least the right to the right of first refusal if they go to sell it to somebody else. And then we have another issue here. Let's say that you're either closing down the brewery or maybe relocating to a new space. What happens with everything that's there? What happens in the space when the lease is terminated? The biggest issue is going to be the removal of equipment, because the lease is going to say that usually that the tenant can remove their trade fixtures. And then we get into an argument over what's a trade fixture. And typically there's trade fixtures and there's fixtures. Fixtures are things that become so attached to the property that it would cause damage, and sometimes significant damage, to remove them from the property. This is where it gets dicey in the context of a brewery, because okay, so you might have tanks that are bolted to the floor. Are they removable? Well, they probably are. I mean, unbolting something is not going to be something that causes a lot of damage compared to, like, pulling, electrical fixtures off the wall or out of the ceiling and then leaving bare wires or other damage, right? So you get into a back and forth with the landlord, and again, it gets sometimes depends upon the reasonableness of the landlord. I'm working with a client right now that has we relocated to a larger space many years ago, and we're just winding down the lease at the old space, and the landlord is basically asking my client to put the space back the way it was when we leased it over a decade ago, and that's not really a reasonable ask. And there, so we're working through it, but again, this that's more a product of a being more of a difficult landlord situation. But you do have to address this as to what happens with stuff. This is why a lot of times, if you're if you're if you're looking to move on and maybe expand to a new space, this is where I've seen a lot of breweries that will simply sell. They will buy new equipment and put it into the new space, and they will sell the old equipment to another brewery that's going to come into the space, do a new lease with the landlord, and do their own brewery there. I have seen that on multiple occasions, and it just ends up the parties decide it's just easier to do things that way than to try to take equipment, maybe even some of it that was put in before the improvements were completed, so it would be difficult to remove it. Um, Again, without damage. And so it's just easier to sell the stuff and buy new stuff and put the new stuff into the new space. Um, so another issue that you you know, have to deal with when it comes to the end the end of the lease, but in terms of if you choose not to renew, or if the lease expires. It also comes up even if you let's say that you're in default, the landlord evicted you, you still have to figure out how to deal with the equipment. And then your lender may get involved too, because the lender probably has the first priority lien on the equipment, and then it's for your lender and your landlord to fight over how they're getting the stuff out of there. And I have a bank client that's dealing with that right now. Is the business, their borrower is going out of business, and we're making arrangements with the landlord to get access to the space and to take our collateral out of there. So a lot of moving parts when it comes to the termination of a lease and what happens with stuff. So looks like by my time we're getting a little. Well, we got a few more minutes. That is, if anybody has any questions, again, please put them in the comments. I'm happy to answer them. So I'm trying to think if there's anything else. We'll cover one thing. If you're in a multi-tenant space, sometimes you'll see, in as an exhibit, rules and regulations for the space. Just be aware of those. If there's any exclusives, just be aware of those. Again, it's another one of those things I can't stress enough. Have someone who's experienced with commercial leases, preferably an attorney, but if not an attorney, your broker. Look through that lease and give feedback, and spot any issues before you enter into it. So I'm not seeing any questions or comments in the chat. So I think at this point, I've kind of covered everything that I was going to cover. I appreciate everybody tuning in. If anybody has any questions following, please feel free to reach out, and I'm happy to discuss any issues you might have. So with that, I appreciate you tuning in, and everyone have a great day.